Good evening, everyone. Welcome to the Wareham Planning Board, Monday, June 26, 2023. Also, in addition to in person here at 48 Marion Road, we are also online via Zoom as stated in the agenda posted on the website. So we will call the meeting to order with a roll call. Sherry Corrick?
Here.
Mike Baptiste?
Here.
Jane Gleason?
Here.
Sam Corbett?
Here.
Al Schultz?
Here.
And the chair, Michael King, is here. We have a full board. I'm going to shuffle things around a little bit because there's a little bit of housekeeping that it'll just make things, I think, go by quicker for us. Ken, on item number 3 on preliminary business, because 025 withdrew their application, do we have to formally close the public hearing?
You already did close the public hearing.
We reopened.
We opened it again.
That's right, you did, didn't you?
Uh-huh.
Well, the attorney's here.
I can explain.
Okay. If you'd like to come forward.
Sure. So, John Clavin's Clavin's Law Group for Wareham PV 1 LLC, and on the Zoom call is Lindsay Kester from Long Road. So the current status is the board had disapproved our application and then rescinded its disapproval and reopened the public hearing. And the idea was we would then take a journey together and dive deep on battery energy storage safety issues and emerge on the other side of this journey smarter and hopefully with approval of the full project as originally envisioned. At that point, we paused a bit to think what's really the most expedient way forward here. And our thought was the most expedient way forward at this time, which we thought would appeal very much to this board because the battery energy storage component was giving you so much concern, would be to, with your approval, withdraw our application without prejudice to facilitate our prompt filing of a replacement application for a solar-only project. The project would look exactly the same as the project that you know extremely well for all these many months, minus the battery energy storage component. There's an argument under Massachusetts law that we might not need your approval to withdraw and file for a project that would be significantly different. But there's enough of a question that we thought it made sense to ask for your approval. So we do this collaboratively, and we'd like to do that now. We're already putting the finishing touches on a replacement application. And our hope is that it would be an easy process. We would file that instead of reopening the public hearing on the, or continuing with the reopened public hearing on the solar project, including battery storage. We would file this new application, and there'd be it would start a new public hearing process on that replacement project. We hope that we could work with you to do that very efficiently. We don't need to take many, many months to basically go over the same ground. You'd have the ability to incorporate into the record of the new public hearing everything from the record of the old public hearing. You'd still have an opportunity to ask questions. The public would still have an opportunity at the new public hearing to provide comments to the extent any remain, but we could move forward. We had submitted a letter providing a little more explanation of this, trying to answer in advance some questions we thought you might have. One of which was, how can we continue with a program in the SMART program, project in the SMART program, without battery storage? Well, we took a harder look at that. There's a path to ask the state for an exception to the storage requirement. We've already put together an application to the Department of Energy Resources to do that. We are confident that the exception will be granted. It's technically an exception that's granted for good cause, but the department has also issued some policies that make it possible in these particular circumstances. So we did some extra homework, found a regulatory path forward if need be. We thought you might also want to know, do we think that battery storage is not safe for this site? That's not the case. We think it's safe. And we may come back to you and say, we've all learned more about storage. Perhaps technology has advanced even further than it has today. I know there were some concerns and hopes along those lines. So that we might come back to you in the future and say, let's add battery storage back in. But that would be a modification of the project, which would of course require your approval. So I'm happy to answer any other questions about what we're proposing. Yeah.
Thank you very much for the clear explanation. My questions are procedural. Mr. Chairman, through you to Mr. Buckland, which version of the bylaws will the resubmitted application be subject to?
They had filed an A&R, so they have protection.
Protection, so it's still the 2019 version of the bylaws?
That's correct.
Okay, that was my suspicion, but that's on the record. Would it be your intention, and again, I understand what you're doing, if you withdrew and then resubmitted, would we have to rehash the whole decommissioning cost issue again?
No. We'll update it to remove the battery storage equipment. So
Of course,
that's an accurate estimate.
yeah.
But other than that, everything is, not only that, but we've already planned in this application to proactively incorporate anything we've learned about your wishes. So in particular, Mr. Schultz and Ms. Gleason, the requests and comments about the pollinator-friendly seeding mix in the draft application, which we're just working on today, it references that revised seeding mix from the Fearing Hill project, to just get that up front to it.
Great. Well, and Jane, you were satisfied with that, or you had a couple of comments on that? We should go back and review that.
Yeah, we should go back and look at it.
But, okay, any change we make to that seeding mix will be minor, but basically what I'm hearing
Right.
is you're okay with that.
Right.
I mean, my previous review of it tells me that that was okay, but I would like to look at it.
Well, you had some comment, because this was a little different soil mix, and
Yeah,
but having a pollinator mix that's aggressive and sustained, good.
well, I'm
Yes.
looking to not have so much of a monoculture.
Right.
Yeah,
Okay.
and I had made a note of that the version that Mr. Schultz had uploaded to the website had maybe 95% of one thing when it should have more of another.
More diversity.
Our goal is whatever you want.
Great.
So,
Okay. Yeah, and we're not trying to rehash that. We just want to get to a good solution for the site.
exactly.
Yeah, should this all move forward, of course.
Right.
I don't think that, and then the barriers are the same, the setbacks will be the same, the buffers will all be the same.
Right.
So we're not going to have to adjudicate any of those things we've spent all those years
No.
agreeing on. Okay.
No.
What about the commissioning costs, the NREL
We would again use the NREL figures. It would just be using the figures per megawatt solar, not adding in the extra NREL component for storage. That's all,
Okay.
to have it be accurate to the equipment that we're proposing.
And then I had just one more question. To be clear then, any future modification to the site plan special permit, which we never solved the issue of site plan special permit, but we did, we're not going to go through site plan special permit again, so, right, on this new application? Are you filing for a site plan special permit or just a site plan review?
Well, it's the same bylaw, the solar bylaw plus the site plan review
Good.
bylaw.
We're not going to spend any time discussing that.
That point.
Yeah, we
Okay,
don't- we
good.
don't need to argue.
No, that wasn't going to be my question. So to be clear,
Yeah.
in the future, should you come back for a battery storage component, that would be a major modification to this, to anything that got approved.
Yeah,
I want it to be clear that it's a major modification, not a minor modification.
Yeah, I knew you were going to ask that, and I
Okay,
knew I was going to say yes.
okay, great.
Absolutely.
Well, also, it's for the public to hear as well, that it would go through the whole, if it's a major modification, that means we reopen the public hearing and to talk about the batteries in the future. So that's not
Yeah.
going to get swept under the,
No, but particularly given the highly sensitive nature of the battery storage component, that would be a major modification.
thank you.
Yeah,
I was just trying to get that out in the,
understood, anticipated,
Out of the public.
totally clear.
thank you. I thank you for your time and everything you've put forth.
Sam, do you have anything?
Nope, I understand exactly what's going on.
Mike?
I have one question.
No? You already had your question?
Yeah, I just want to be, just belt, suspenders, and whatever other pieces of protective equipment one might want to wear. And the major modification would be before this body, correct? If you were to add battery storage.
Yes, yes, this is the body that's issuing the permit.
Right.
So this is the body we'd have to come back to for a change.
Okay. And I just have to say that I appreciate this, because I think that you saw the level of angst that this was causing to this board and to the town more generally. And you reacted to it in a way that I think shows some understanding and sensitivity to the town's position. So I just want to tell you that I appreciate that.
Yeah, and we understand that, you know, with this project, we're proposing a significantly easier path for the board, but with other projects, you may not have that option, and there may still be a learning curve and some tough decisions to make on battery storage and battery storage safety, how to reasonably regulate it. The other point we made in our letter was we'd like to keep an eye on it. You know, I'm going to stay through this meeting to hear whatever presentation is on battery storage safety. We still have an interest in playing some role, we don't quite know what, in helping this board get itself educated and positioned to deal with these projects.
Okay. Anybody else? No?
Are you going to hear from the public on this?
I will allow some public comment as long as it pertains to subject matter that hasn't been heard. If we're going to rehash old information in the attempt to sway the board's decision one way or another, I don't see the benefit in that. So
Okay, so
there's
it's
something-
specific to
wait a
this
minute,
question
wait
of
a
whether or
minute.
not you need a
Excuse
new
me.
public hearing.
Hello, excuse me. Before you rattle on, first thing I'd like you to do is identify yourself and then ask permission to speak. So if you'd like to do that, go ahead.
Barry Cosgrove, permission to speak, please?
Sure. Again, you know, pertaining to the criteria that I just mentioned, feel free.
Thank you. So the question that was raised tonight is whether or not this requires a new public hearing and a renoticing of a public hearing. And the answer, I think, under Massachusetts law is clearly yes. Forgetting for a moment the flaws, plural, in the previous rescission of a decision rejecting the project, now a new project is being submitted. And under Massachusetts law, that compels public notice.
Well,
And so
you're
I think
you're
it's been-
anticipating he's submitting it tonight, which is not the case.
No, I'm not anticipating it's submitted tonight. It's obviously in the future.
So
And
when
the
it
question was
comes up,
raised is whether or not it's a new public hearing, and it is, and it should be properly noticed as such. Thank you.
this is a continuing public hearing. It hasn't been closed. It will be closed tonight. So again, if we can speak to relevant information, I'm all for it. Otherwise, you know, we have business to conduct. Is there
Well-
anybody else that needs to speak to this?
So, maybe just to clarify, that although the board voted to reopen the public hearing on the pending application, this is not a public hearing session. We were poised to work with the town planning staff to provide notice of the reopened public hearing and schedule a new public hearing session.
Yep.
But wait a second. Let's not do that.
Yeah.
Let's take out the battery storage part.
It
File a
prob- it
replacement
prob-
application.
It probably would have been better advised to
Yeah.
just rescind the application and not appear, and just call it a life.
We,
Because I think that's what's triggering Mr. Cosgrove, which I kind of understand.
I understand.
So I think at that point, I'm gonna,
I have one process question.
one quick one, and then I'm gonna put the kibosh on all of this.
Okay, one quick one. And I don't know what the process has been in the past if a solar project that was built without a battery component, if batteries have been added to any of those projects. I don't remember ever seeing a project come through just for the batteries.
I don't think it's happened yet.
So
Again.
can we verify that those weren't, that no batteries were ever added?
That has no bearing on this subject. It's already been stated that if they come back to us asking for batteries, it's going to be considered a major modification, and they'll have to have a new public hearing in which everybody can weigh in.
Okay.
But that really has nothing with no bearing on what's going on tonight.
Okay. I just wanted to make sure that there wasn't something in the bylaw that said it's just an accessory structure, and by getting a building permit, they could put a battery in.
No, it doesn't work that way.
Okay.
Thank you.
you very much for putting that on the record. I appreciate it.
Okay.
Thank you for taking the battery out.
Okay. So, I would entertain a motion to close the public hearing on 33-21 Wareham PV 1 LLC, 0 Route 25, large ground-mounted solar array.
Glad to make that motion.
And do we have a second?
Second.
I would add to that, with the understanding that the application is being withdrawn, so that we don't suddenly get stuck with a 60-day window in which
No.
we have to make a decision.
Okay, so let me restate that. Entertain a motion to close the public hearing on 0 Route 25 LLC with the understanding that the applicant has requested that the application be withdrawn without prejudice.
So moved. Second.
We have a motion by Sam Corbett, seconded by Mike Baptiste. All in favor? Sherry?
Aye.
Mike?
Aye.
Jane?
Aye.
Sam?
Aye.
Carl?
Aye.
And the chair votes aye.
Great, look forward to working with you on the next phase.
Thank you very much. Now, Ken, now that we've closed the public hearing, do we actually have to vote to accept the fact that they've withdrawn it, or that's just a foregone conclusion?
I think you should do that just in case.
Just cover our backsides?
Yeah, exactly.
So, having closed the public hearing, I would entertain a motion to accept the withdrawal application for 3321 Wareham PV1 LLC, 0 Route 25, without prejudice. I thought I said that. Okay, without prejudice. Okay. Accept the application without prejudice. Withdraw the request. Accept the request to withdraw the application without prejudice.
So moved.
Do we have a second?
Second.
Motion by Sam Corbett, seconded by Mike Baptiste. All in favor? Sherry?
Aye.
Mike?
Aye.
Jane?
Aye.
Sam?
Aye.
Carl?
Aye.
And the chair votes aye. Thank you for your time. Since we're on the subject of batteries and solar, yeah, that's a good idea. For anybody that might be here for the continued public hearing for 91 and 101 Ferring Hill Road, that project has requested a continuance to 8/28 of this year while they deal with legal matters. So we need to vote to accept that continuance request. So I would entertain a motion to accept the request for continuance for 91 and 101 Ferring Hill Road to August 28, 2023.
So moved.
Do we have a second?
Second.
We have a motion by Carl Schultz, seconded by Sam Corbett. All in favor? Sherry?
Before I vote, can you tell me what the continuance, you said it's being continued for?
They're still in court with conservation.
Aye.
Mike?
Aye.
Jane?
Aye.
Sam?
Aye.
Carl?
Aye.
And the chair votes aye. Okay.
Sherry, could you put your mic closer to your face? Thanks.
Sure.
All right. Let's see here. I don't know which order I want to do these. All right, so preliminary business, item number 1, 7-20, Borrego Solar Systems, 27 Charge Pond Road. Extension, request for extension of time on special permit site plan review. Can we legally do these at the same time, or are we playing with fire?
You can do them at the same time,
Okay, so we will also,
as long as you have a different motion on each one.
okay,
No pun
to
intended.
take the action. Good evening, gentlemen.
Good evening. Gregory Sampson from Sullivan and Worcester on behalf of the applicants for the two projects that were just mentioned. And just, it's been a little while, so I thought I would quickly recap. As you know, we filed requests for recognition of an extension of time for good cause, and we have since that time, since the filing, have worked with the board on a few issues related to the original approvals and updating the decommissioning estimate, which we finished earlier this year. We agreed to the NREL figures that the board had looked at. And then recently, more recently, in March, there was, we thought we were about ready to wrap up, but there were some concerns raised about the battery energy storage systems, which were part of the original application, but I think the board has come to some, realized some concerns with the project. So those are still a part of our projects. They're part of the design that was approved originally, and we are still hoping to have these projects incorporate a battery energy storage. With that in mind, we would be happy to address any of the concerns the board may have with battery energy storage. Our team has a person who specializes in battery energy storage if there's questions that we can respond to. if there's, I understand at one point the board was considering bringing in some outside help. I don't know if that's what's generating the conversation later this evening, which we're happy to listen to. But as said earlier tonight, we're happy to be part of that discussion. We'd be happy to submit additional information if there's updated conditions related to storage projects or requirements that, I think we've tried to demonstrate that we're willing to work with the town, and, through the decommissioning process, hopefully, you all felt we were responsive and willing to advance the project through that, and I think we'd take the same approach with any concerns related to the battery energy storage. So we are still hoping that we get the extensions recognized, but again, we're willing to discuss any of the board's concerns with that aspect of the project in particular.
Okay, thank you very much. Anybody want to weigh on this before I start in?
I'm happy to start.
Okay. Yeah, I'm going to reserve my comments for afterwards, so have at it.
Okay. Well, first, I want to say I appreciate also the information that you put in front of us on battery safety and your plans for going forward with the battery component of this project. And I think that you've laid out some helpful information that represents some of what at least my non-expert research has shown is, the developing state-of-the-art for battery energy storage. I guess what I wanted to do was to lay out what I would say are some remaining questions and just maybe lay them out and ask you to take some time, not necessarily right away tonight, unless you feel like that's when you want to do it, but at some point to come back to us with some ideas. But in particular, and you'll see this, I'm going to do a presentation later tonight on battery energy storage. I wanted to share with you some links to articles that, if you could pass these down. And
Thanks.
I guess, a few things have stood out in my research. One of them is the sort of the sheer amounts of water that can be required, in the event of a battery fire. I've shared with you previously information from EPRI on the fact that these fire incidents do occur, and the incidents that EPRI discussed was 1% to 2%. And so got, fairly, what I'd say is not uncommon, not unknown risk with what appears to be very large requirement for fire to put, for water to put the fire out. And as well as some, toxicity associated with the air that escapes. And, the toxicity of the water, I think, is being examined at this point. I found one study that seemed to demonstrate that there are, toxic effects on sea life, among other things, and groundwater, et cetera. And so, looking at this, it appears that that there are, potential bad effects from the fires. One article that I found described battery storage and the fires that can occur as the new hazmat, with, potentially very dangerous situations emerging. And then just sort of for interest, I threw in an article by Travelers Insurance about the insurance risks associated with battery energy storage and all of the risks that, an insurance company is obviously not only paid to insure risks, but also paid to make sure that the risks are well understood. And so there's, some elucidation of what those risks are. And with this, I was interested in hearing from you, and again, not necessarily tonight, but it seems that it would be very helpful to this board if you were able to describe for us, what your steps would be in the event of a fire event, in the event of fire water runoff in large quantities, and what protections you can offer in terms of, whether it's some kind of, catchment basin or something that would not allow the water to go into groundwater or the aquifer or any other water resources, and to the extent possible, protect. And I think you've heard a lot from this board on concerns about groundwater. So my question to you would be, what can you provide to us in terms of safeguards, where this board can say, if we approve this battery project, we can do it knowing that even if something, very adverse happens, the town, its water resources will be protected. And I don't know how much time you've had to spend in Wareham so far, but the water resources in this town are a big part of the town, and so the concerns are very deep. And I guess I would ask you to think about another thing, which came out also in Mr. Clavin's conversation, which is we're at a particular point in the development of battery storage right now. I think there are some issues right now that not just Wareham, but a lot of towns are struggling with in this state as well as others. Is there merit in just simply waiting as Zero Route 25 is waiting and coming back to this at a later point in time when we can have more certainty about the technology? I know there's a lot of money being invested in battery storage of all types, not just lithium ion. And is there real merit in waiting, recognizing that you've got some other delays that are not, that are not yet over with, and the transmission interconnection agreement being one. I don't know what availability of panels you have at this point, but that's, maybe two questions, some sub-questions, and some information that I would appreciate you looking through and, coming back to us with some responses.
Mr. Chairman, if I might, before the applicant responds, I'd like to thank you, Sherry, for a very comprehensive question. I have a subset of that question, which is very particular, that I'd like to add to your question, if I may. Mm-hmm. So, Sherry articulated the problem very clearly. I would like to focus very, very much on a process question, or I think it's a process question. One of, and I can't, we've got so many solar applications in front of us. One, and I don't remember if it was this one or one of the other ones. The response from our fire department was somewhat soft in that the response said the incident commander or the first person on scene to a fire would make the decision on how to respond to that incident. So that's sort of where we're at the moment. I would like to ask, I've done some research in terms of fire laws, fire response, and one of the things that has been put forth in many of the things I've read, and I'm sorry I don't have reference because it's just my reading, is the requirement for fire departments to have an incident response plan. I don't know if our fire department has an incident response plan. That may be something we want to pursue separately, but they certainly didn't present an incident response plan in our request for feedback. So I think a two-part question, or a multi-part question. One, do you have experience in assisting town fire departments prepare incident response plans, which goes, I think, to the heart of what Ms. Quirk was asking about, what do we do if there's a fire? So do you have experience preparing those incident response plans? Do you have examples that you might provide? And two, if you do feel you're qualified to participate in that, would you be willing to work with our fire department to prepare a formal incident response plan associated with these two applications? I'm not sure if that makes any difference, but it's just a consideration. The uncertainty, we're trying to remove uncertainties when you mitigate risk.
Yeah,
So-
and I would just maybe refine what your finer point even more, which is, I think that providing an incident response program, providing, training for our fire department is contemplated by what you have already put in front of us, the 855, 9540 for the testing of the equipment. My question is very particular, which is, with a particular part of the response, how do you protect against fire water runoff and the possible toxic effects of that?
Yeah. And if I can refine that point a little bit further, to Carl's point about a response plan for a potential fire. So I actually did receive today, late today, and I do have copies for everybody, a response from Wareham Fire concerning this specific question. So yeah. So I'll read it into the record, and then everybody can have a copy for your records. So this is from the fire prevention officer for Wareham Fire, dated today, and it's in response to a short meeting that he and I had a couple of weeks ago, where I asked him specifically, should we have an event, how would the fire department react? What is their plan? So his response: Dear Chairman King, I'm writing to you as a follow-up to our discussion regarding potential hazards related to solar and energy storage facilities. The topic of fire suppression tactics has been debated lately because of the potential for hazardous water runoff. Unfortunately, we cannot provide a specific fire suppression tactical plan for these ESS facilities. It would be at the discretion of the officer in charge to mitigate the hazard in the safest manner possible. These tactics may range from trying to extinguish the fire, to letting the storage container burn, or smothering to ensure that the fire does not spread. Feel free to contact our offices if any of the planning board members have any additional questions regarding this matter. We'd be happy to attend a future meeting to answer any possible questions. Respectfully, Captain Christopher Smith, Fire Prevention. So, like I said, I received this late today.
Thank you.
So, I think we've drilled down into the fire response question pretty
Sure.
deeply now, so.
So if I can offer a response, I mean, so first, we're more than, again, we're always very happy to work with the board and the town. I think we would like the opportunity to respond in writing. I think we probably would like the opportunity to meet with the fire department and maybe discuss the best path forward to provide a response that works It's one thing if we put a response on paper, but we also have to have a little bit of comfort level that it works for the fire department. I'm sure that would
Yeah.
get you past.
I'm
his-
sure they'd
his concerns.
appreciate you not telling them how to put the fire out.
That's right, especially, bring the, jumbo jet to drop the forest water on it. We'd be happy to respond. I think, it's all very reasonable requests for information. I don't, and we're not going to pretend to answer these things tonight, but I do think, it's all very straightforward, and we'd be happy to listen to the presentation tonight to see if there's anything else that prompts additional information for us to respond to. I think we would need, especially given the time of year, really, I don't think this is a 2-week turnaround to come back to you with this.
I would have to agree with
Yeah,
that.
so, what would be,
I actually was going to ask, because I think I got pretty good notes on everything that Ms. Quirk and Mr. Schultz were saying, but maybe a good first step might be just to, if we could get the list of questions that we heard, communicate about that, and make sure that that's the group of questions that you want us to answer. If we got a clear scope on that and what we all agreed on, you guys wanted us to take a pass at trying to give you the materials for, I think we'd probably, once we get that, I think 2 or 3 weeks to put together a good, wholesome response for you folks would be reasonable.
Okay. Well, I mean, Sherry and Carl were both pretty clear in what they were hoping to get. If your notes don't reflect that, I mean, the meeting is recorded. You can grab it on
Good point.
Zoom
Fair point.
and just review.
Yep. I just want to make sure I have a full and comprehensive list of the current concerns that are on the board's mind
Mhm.
today.
And I
So,
have something that I'd like to add to the concerns.
You're going to drill down even further?
Yeah,
Okay.
if I may.
Of course. Go ahead.
So the conversation about groundwater contaminants, if there's in the case of a fire and there's a boatload of water used to put it out, one of the considerations has been about containment. And I would like to see that taken a step further in the consideration that if it is a matter of containment of that water, that there be also some consideration of what the resultant
What's
fluid,
done with the water?
what that fluid is that's left, and how do you get rid of it, or how do you treat it so that it can be gotten rid of in an environmentally responsible way.
That's a good add.
It's similar to our consideration of what you do with all the panels when they become obsolete. We got to think about, if there's 10,000 gallons of water, that's not insignificant, and you need to think about what the makeup of that is and how you get rid of it.
And I think at 10,000 gallons, I think that's a fire that got put out really fast.
Yeah, I mean, maybe
All
it's-
conversations have been considerably larger volumes.
It's even more of an issue then.
So obviously something to take back is not only if there is a fire and there is water, what's the containment plan, and then what do you do with the product after, the byproduct
Right, and we
afterwards.
don't want to find ourselves in a situation where, yes, the fire was put out, there was a prodigious amount of water used, and it's in a tank, and it's sitting in the town of Wareham, just sitting there. Nobody knows what to do with it.
Good point.
Mr. Chairman,
Yes, sir.
this is a process suggestion. In order to improve and maintain good communications, I think you suggested that the applicant could determine what we were asking by reviewing the tape. And it's there, it's very, very clear. I'd like to add a further step, if the applicant's willing. If, before you begin your deliberations, if you just simply wrote that list of points out, and Sherry, I don't know, if you send it to the chairman or to Sherry and I, we would be glad to vet that list and say, you got it,
Or you
or
missed something.
you missed something.
Sure.
If
That's
that's
what I
okay.
was- that's
Rather
what-
than having you spend hours and hours and days going down and, oh, you completely
You missed one point.
missed one point or something.
that's what I meant, yeah, and obviously we can review the tape and everything, but just to make sure that nothing was lost in translation or
Yeah.
it was misinterpreted or whatever,
Yeah.
just to make sure that we're working on the set of things that you guys want.
Right.
So
It'd be
Sherry-
better-
Sherry's, go ahead.
Sorry,
Mike.
I say it would be better to Kyle's point, that you sent us the list and said, all right, we interpret your request as X, Y, and Z. Do you concur? And
No
if the
doubt.
answer
Yep.
is yes, then you have your path forward to work on it.
Right, and if they send it to you, you can decide if you want Sherry and I to vet it, or you're going to vet it, or however we respond. But I think we should try and turn that around as quickly as we can.
Yeah, and it'd probably be prudent to send it to the planning office, and
Yeah.
then they can forward it.
Thank you.
Okay. So, judging that it's not going to be a 2-week process, which I agree with, I don't think it will be.
We'd rather, I mean, Mr. Chairman, we'd rather have the right amount of time to get the answers than.
Yeah, no, I agree.
Okay.
There's no sense in rushing it and
Right.
have you come back and have us say, hey, what were you thinking?
Right.
Yeah, no, I agree with that. So is 4 weeks enough? Would the second meeting in July be appropriate, or do you want to push it out even another 2 weeks past that?
What would the first meeting in August be, sir?
First meeting in August would be August 14th.
I'm going to be on vacation I think that day.
Okay, now, we do want a full board.
Are you
So,
gonna be gone?
Yeah, I was going to be on vacation, but I'm only going to be in Carver, so I could
you could come back.
come back.
Or you could fly back in.
Yeah.
I'm going to be in England because
So,
I'm not going to say.
so you can push the envelope a little bit and go for July 24th, or you can stretch it out a little further and go to August 28th.
I think Greg has a conflict on July 24th. It was
How
the
about
second.
August 28th?
Yeah. Oh, yeah.
Okay, and right now, there's another
We're not supposed to be in
solar project
Okay.
that's scheduled for August 28th as well, but I'll make a commitment to you that you'll be heard first.
Thank you.
On the 28th?
Yeah.
Okay.
And we'll make sure we get everything submitted ahead of time, and so that gives us plenty of time for that.
Mr. Chairman, through you to Mr. Buckland. Mr. Buckland, if the applicant submits a response ahead of time, which they've committed to doing, which is sufficient time for us to review, is there a method, because the next meeting is out in August, is there a method for us to either ask clarifying questions or ask for additional information, or do we need to wait for that meeting?
If you pass those questions on through my office, then we could pass it on to them and be the mediator.
Okay, so we wouldn't deliberate as a board, but individually,
Individually, we could ask questions or pass questions to the planning office.
Right.
Yeah.
through you. Okay,
Okay.
so we're not going to have to wait and get to the meeting and say, you really missed what I wanted to know.
Right.
Okay, great, thank
All
you.
right, good. Anything else? Okay,
Thank you.
all right, thanks for coming by tonight.
Appreciate your time. Thank you.
No, it's not a public hearing.
Continue.
So
No, you don't have to continue.
no, it's just an ongoing, open discussion. Jeez, Kyle, I'm on fire tonight. Damn. Okay. Next up is the subcommittee report by Carl Schultz on the Bay Point Club LLC, 19 Bay Point Drive.
Okay. In response, I think to some frustrations the board may have felt, I know some frustrations the planning office may have felt, and the applicant, about communications and process with Bay Point. I think the board informally appointed a subcommittee of one to interface with Mr. Fay of Stone Street to try and facilitate keeping things moving in a positive direction, and I've agreed to do that. That's fair, right, Mr.?
That's a fair point.
Yeah, okay. So to that end, I met with Mr. Fay on June 19th at the Bay Point Club, not in the clubhouse, but in the,
Eventually.
the wedding venue or whatever it's called.
The event center.
The event center, yes.
It's at the
And we had a very positive interaction. Mr. Fay was quite, I mean, he was frustrated, and he expressed his frustrations, and we had an open dialogue. And we made, at the end, I'll go through an action plan that we sort of agreed to at this point. But a couple of things we sort of agreed to, I'm not hedging. We agreed to that in order to improve communications going forward, if Mr. Fay presents an updated set of plans or engineering drawings or anything that's a diagram, not a point of law or a point of process, in general, we agreed that Attorney Rosa is probably not the best person to represent the applicant. And we agreed that if such plans or updates or modifications or drawings or design or pictures or anything that's engineering in nature, that either Mr. Fay would attend or a representative of his engineering firm, so that if we did need to have discussions, or a simple thing like on the last A&R, we couldn't read a line on the diagram that could have been resolved more simply. Certainly Attorney Rosa was not the right person to answer that question. So we've agreed that in the future, should they submit drawings, plan, et cetera, that either he or an engineer would attend. I also, and I have to continue to talk with the board and Attorney Buckland, we should probably have our peer review engineer at those meetings, and that could be paid for out of the 53G account. That would, I think, serve to improve communications, answer questions, and minimize
Friction?
well, just
Miscommunication?
missed opportunities, so we don't have 6 weeks going by on what should have been a simple A&R request, as an example. So he agreed to that. I think in the future, when they're on the agenda, Mr. Buckland, if they're submitting diagrams, that you and Chairman King should reinforce the need for the applicant to be here. And I think that if we open an agenda item and the applicant isn't present, we should take some action, I don't know, but not get ourselves wrapped around the axle trying to understand the plan if it's not a simple issue. So we sort of agreed to that. So hopefully we'll try it out. We'll see if that improves communications. That was agreed to. The next thing, we did talk about the process for the 2 A&Rs that had been before us previously. The A&R with respect to the properties on Onset Avenue has been withdrawn, and at the moment I don't think there's any plans to resubmit that A&R, so that's done. The the A&R with respect to the property on Bay Point Drive was approved, and there was a requirement that a minor modification be made to the site plan special permit. And that was communicated to Mr. Fay, that he needs to update the drawings, file review with the town planner, or excuse me, the planning office director, and the process for a minor modification is they agree, work it out. That minor modification needs to be stamped in with the clerk, filed with the Plymouth Registry of Deeds to close off that action item. That's sort of his action item and Mr. Buckland's action item. I don't think the board, other than being informed that that happened, I don't believe there's any further involvement with the board. We should be awaiting for that action to occur. Okay. Now, with respect to the 4 phases of the project, we'll take it by phase, which is their definition. Mr. Fay believes that all of the work associated with phase 1 has been completed, or the items have been moved to phase 2 and are contained in the plan for phase 2. That's his contention. That's his belief. He has submitted a request to that end Mr. Buckland has received that, and the action item there is for our town engineer, our peer review engineer, to review Phase 1, the conditions thereof, and give the planning board a report. Done, not done. Is that your understanding with?
I had a conversation with Phil Cordero, our consulting engineer, about this, and he wants an as-built plan, which makes a lot of sense. But an as-built plan would identify things that weren't done, and apparently anything that wasn't done would be shifted into Phase 2, which suggests that the as-built plan is not an as-built plan.
Why would it be shifted into Phase 2? Why wouldn't it just be
Well,
I
completed?
don't understand that either.
There were, no, in January of this year, before January of this year, December of last year, we had a meeting with the applicant, with Charlie Rowley, and there was an agreement reached for some of the items, and they're documented in the Phase 2, at least schedule. So, I'll hold on the as-built plan because that's new information, but the idea would have been that we get the engineering report of what's done or remains to be done and use that as the next point in negotiations for completeness. But question about the as-built plan. In the rewrite of Article 15, we're going to request as-built plans, but I don't believe the current bylaw or subdivision control law requires as-built plans. Can we reasonably request that?
I think we can, yes. That's standard procedure.
Okay, I'm not arguing, I just want to, okay, so that was not discussed with Mr. Fay, so we need to make some decisions on that, and then we have to request it of him. But in any case, the way we left it for Phase 1 is we'd get a checklist, done, not done, and from there, the board would have to take some actions. Do you have a question? I can see it. I can.
You can smell the burning rubber?
Yes, yes.
Is there a monetary implication behind closing out Phase 1 and moving some punch list items to Phase 2?
Okay.
He's shaking his head, yes.
Actually, I don't. There's a tripartite agreement, which, so first of all, the town doesn't have any of that money. We, the board, the planning office, and Mr. Fay have been going around and around about Phase 1 tripartite agreement. Mr. Fay's contention is that the bank that would have been withholding any funds for that tripartite agreement is no longer involved. So to the best of my ability to discover, there are no funds being held for Phase 1.
Against Phase 1?
Against Phase 1. I can't find anything more than Mr. Fay's statement that the bank is no longer involved. They aren't holding. He's paid off the loan or whatever. So he doesn't have any obligation or anything being held by them. The town doesn't have a covenant. So I don't think there's any for Phase 1, there's any financial. I'll talk about Phase 2, Phase 3, and in a minute.
Other than paying for the work that's not finished.
Didn't his
Yeah.
attorney say there was one?
The attorney
but-
stated that there was a
but-
bond in place.
I can't find it.
Right, no, and I believe that.
So
So, but
regardless, is the town isn't holding any of that money. That money would be being held in the tripartite agreement by a bank.
It's just an interesting strategy to take some components from Phase 1 and close Phase 1 out by moving those
Moving the
components.
There was some good reasons at the discussion time, and Mr. Rowley recommended that, and I think they were written into the covenant, but
Is there a time
no.
constraint?
Yes, there are time constraints on the tripartite agreement.
And on Phase
When it
1,
comes-
on closing out Phase 1?
Well, the tripartite agreement expired 2 years ago and was never extended. I brought this up at earlier meetings. I mistakenly thought that the tripartite agreement for Phase 2 was expiring. I was off by a year, so we have another year on that one. In any case, I have not been able to find documentary evidence of the schedule of values for Phase 1 and the releases. So
Can we,
Wait,
is it possible?
How about if I give them, okay.
Is it possible that we can approach this from a basic blue-collar, common-sense point of view?
Let's try.
What's the list of items that are not completed in Phase 1?
That's-
Determined by our town engineer, if, our, so, you know, our contract engineer. If he wants an as-built to compare that list against, what's the harm in giving it to him? And then, whatever that list is, if it's 2 items or 20 items, that unfinished list has to be completed before anything else goes forward.
And,
I agree 100%.
and Mr. Fay agrees with that. So,
Mr. Fay always agrees,
wait,
but he doesn't do it.
He doesn't follow through.
He
I
doesn't
have to
follow
agree with
through.
Sam.
That's what happens. Moving into Phase 2 doesn't make sense.
that was already done, and it's documented on the modification.
I don't care. We need to hold him
All right,
accountable.
I'm just giving a status report. I'm not
Oh, Carl, I
negotiating.
agree. You did amazing work. I'm just saying, I've been sitting here for 2 years, and he always agrees. We had a meeting with him. He had a punch list of things. He didn't do it. And we sit here week after week, and he agrees, and I'll do this, and we got a list, and we're gonna do it by this date, but he doesn't do it. And I
So-
applaud your point.
So based on your discovery, what's his next ask?
His next ask is for us to do exactly what you said. Do the inspection, prepare a list of things that we think aren't complete, confirm that they're not part of the Phase 2 tripartite agreement or schedule of values,
And then get him done?
and then get them done.
Okay, and does he accept the fact that until that list as identified is finished, don't come back?
Exactly.
Don't ask for anything else?
Exactly.
No, that has not been discussed.
Okay, because that would be
That
my
need-
point.
That's a
That's my
different,
point.
so let me get through this and we can
Okay.
discuss that. But until we have something in front of us, an updated schedule of values or an updated report,
Showing uncompleted work.
we could all wave our hands and say, he says it's done, we say it's not done. The residents, we need something in front of us that we're all working
Well,
from.
I think having the town engineer
That was the ask.
had the as-built, so let's start there.
Okay, so Ken, between you and I, we need to respond to
Yeah, we'll
His
get back to Tim
action.
Fay and tell him we don't have built so we can give it to the engineer to compare.
Right, and then perhaps if we're going to look for as-bills for each of the future phases,
He should be made aware of that.
he should be made aware of that, because I don't believe it's part of the conditions of approval.
And is there sufficient money in the 53G to pay for the engineer's work?
There is now, but there will probably not be in the future. We just have to keep adding into it as we go along.
All right, just so Tim's aware
Okay.
of it.
So,
He is.
Okay.
just as a learning, if we're going to be looking for as-built plans in the future, if it's not clear in the bylaws, and I believe having deeply delved into Article 15 site plan special permit, it does not require as-built plans, or I've missed it, until we
Check
can...
the subdivision rules and regulations. I think it's in there.
Okay, but some of this is not a subdivision, but
Well, it is the subdivision we're talking about, though, which is.
In
which
phase
under
one-
the
phase one was-
tripartite
yes,
agreement.
okay.
But is he asking for us to give him a release on something that is not
no, he just wants to close it out, so
typical?
we're
that
not...
We need confirmation, and that's what the as-bills are. It's not
That's,
necessarily.
I'm only reporting what
Yeah.
he agreed to, responding to the list of items. How we get to that list of items, if we need an as-built plan, then let's ask that.
Yeah, regardless of
Once
what
we
the
get that
bylaws are.
list, updated schedule of values or whatever the report from our engineer that says this, and this were scheduled to be done as part of Phase 1, they're not. This, and this were agreed to and moved to the conditions of approval for Phase 2, then everybody's back to working on the same page.
Yep.
Once we're satisfied with that, the board's action items, I think, are administrative. Before I move on to that, Ken, if you and I can follow up, maybe we just go back to Tim and Attorney Rosa and just reconfirm my assumption that I know the tripartite agreement expired and was never extended. Therefore, I don't believe there's any escrow funds remaining to be released, because I sat there with him for 2 hours and he never once asked for funds for Phase 1. So I don't think he's worried about monies to be released from Phase 1.
No, but he's gonna be worried about monies expended to complete what's not done.
That's, we don't know what that is, but until we get there, that would be his problem.
Right.
But I don't think there's anything remaining. So, again, with Phase 1, the new action, but we got to get an as-built report, but until our engineer goes out and gives us
A detailed.
a detailed report, it says, to his satisfaction, it's either done or not done,
Okay.
that's the next step for Phase 1.
So that's an action item for the planning office to arrange that to happen?
As soon as we get, as soon as we get the as-built, yeah.
Yeah, and the planning, I'll continue to work as the subcommittee.
Okay.
Once we get that as-built, I believe there are some Phase 1 administrative items that need to be done. I cannot find any record that we actually released the covenant for Phase 1, so I don't know if it's still recorded at the Plymouth Registry of Deeds or not. That's something I can work with the planning office on, or we can work with Attorney Rosa on. But I don't think we ever, I went through the tapes, I went through the meeting minutes, I could not find a vote to release the covenant for Phase 1. I did find the vote to instantiate the tripartite agreement, which has expired. Notwithstanding that, that it's expired, once we're satisfied that Phase 1 is done, to clean up the records, we should vote and release the tripartite agreement. Even though it may have no effect other than it gets filed at the Plymouth Registry of
Just
Deeds.
tidy up everything.
It keeps, and then we have a record, the covenant was released, the tripartite agreement was released, Phase 1 is done, and we can report to the citizens of the town that Phase 1 is done.
Yep.
To that end, we also discussed, you and I both received a letter from a citizen about the road. There was a distance of road up to, I think, 34, don't hold me to the exact address. Anyway, it was the road up to a point certain, and after that, work had not been completed. That was the citizen's concern. I have confirmed with the planning office that the point that was identified matches to a station ID on the map, and the work that was being described, keep me honest, Ken, what I'm saying,
Yeah.
extends beyond Bay Point's responsibility, and the road at that point belongs to the town, and those issues need to be dealt with at the town. That road is town road at that point.
Cahoon Drive.
Cahoon Drive, yes. You're satisfied I got that right from our...
Yeah,
our work?
Cahoon Drive is our responsibility.
Yes, so those issues,
Are town-oriented?
town-related. Okay. I think that covers everything on Phase 1. We'll be able to resolve what's open, what's closed, but just a couple of things. The street light that we were worried about is in. The sidewalk from Bay Point Drive all the way down to Onset Avenue is in. Those were two big issues that I think those are done. But there's minor points. I think Mr. Buckland pointed out the cement bounds are not located, so that would be an open item that the engineer should find, and I have to check to see if that's one of the items that got moved to Phase 2. Let me get all the way through, and then if the chair wants, you can ask questions. Moving on to Phase 2, Mr. Fay would like to update the schedule of values for Phase 2 and get additional releases. The last schedule of values we looked at, I think, was at the end of 2022. Mr. Rowley worked with their engineer, and there was an updated schedule of values, and we did a release. He wants the next release. He believes more work is done. So the work there is we've requested that he updates the schedule of values for Phase 2 from his perspective, that our engineer, just as the same process we've always followed, our engineer reviews the updated schedule of values, advises us, we do whatever negotiations are required, and Mr. Fay is okay with that. He's going to update the schedule of values. Mr. Buckland sent him that note that he needs to provide the updated schedule of values. Then we'll review that. Our engineer will review that, and that should be the next step there. That's, phase 2 is not done, but that's the next action item there. Phase 2 is currently under a tripartite agreement. As I said, I was mistaken in thinking that it expired this August. That agreement expires next August, so it's still valid and in place. Phase 3, which is Beacon Drive or Beacon Street, is under covenant. So that's different than the tripartite agreement. Mr. Fay is ready to begin selling those lots. So he wants to convert the covenant to a tripartite agreement, which is what we've been doing all along. So to that, the next action item for that is that he has to prepare a schedule of values, because he says most of the work is done on that, but he needs to prepare a schedule of values. Our engineer has to review the schedule of values. Once we agree on the schedule of values, then we release the covenant, do the Form F, release the covenant. Then we instantiate the tripartite agreement, substantially in the form of the existing tripartite agreements with just different dates and different descriptions on the property and different amount that matches the schedule of values. So we release the covenant, we adopt the tripartite agreement, and once he has the tripartite agreement in place, and that's the form of that surety, he can begin selling properties. So his action item is to prepare the schedule of values and the draft language for the tripartite agreement, get that to Mr. Buckland. Once we review and agree on the schedule of values, we can release the covenant and then adopt the tripartite. That covers phase 3. Okay? All right. Phase 4. Phase 4 was a major modification to the site plan special permit. It was not a subdivision. To the best of our ability to determine, there's no covenant required. So there's no holding of funds because we're not building streets. We don't need any. And at the moment, we don't have site plan special review. Article 15 doesn't talk about performance guarantees, which Sherry and I are working to add to the modification, so that where we need performance guarantees that aren't covered by covenant or other form of surety, we can still have some performance guarantees if we feel. We can't do that in this case, but that's, so at this point, I think we've confirmed that he doesn't need a covenant. The only thing he needs to do before he can move forward on phase 4 is to file the minor modification to the special permit site plan review that transfers the ownership from Windward Pines to Stone Street Corporation as needed, so that the right persons are the right owners for the right lots. And that covers phase 4. We did discuss construction vehicles accessing Cahoon Drive from Onset Avenue down by Lacoste. He has committed that that has stopped and he's not doing it any longer. That's done. We discussed the confusion about the closure of Bay Point Drive, and we discussed the reasons that you couldn't close half of it and leave half of it open. The requirement in the conditions were that he dig the entire thing out, go all the way down to whatever you call the base level. And if you dug out half of it and left half of the road, you'd have a 20-inch drop.
Which is not a good thing.
No, it would not. So there was no, in his mind, it was always anticipated that that would have to happen. We can get into, he said it, she said at this point, he thought he notified everybody. How the miscommunications happened, not sure, but we talked through it, and I think that's behind us now anyway. The road's done. It has to get inspected, I guess, right, to get accepted, or to get as part of the conditions, but.
It's supposed to be inspected.
Right, so that's part of, that was part of phase 2 schedule, right?
Right.
So that would be part of the schedule of values that get updated for phase 2. The road has to get inspected. And so we talked about that. So Cahoon Drive from Onset Avenue by Lacoste not being used anymore, he understands that. The other issue, I don't remember if it was citizen complaint, but the issue with citizens exiting Bay Point through Cahoon Drive the other way is not a Bay Point issue, that's a town issue. That's the town road, those conditions were town conditions. There are deed restrictions on those deeds, but it's not something that Mr., in his opinion, and I think I checked with you, and that's...
No, that's incorrect.
Okay.
The decision had restricted him from using Short Neck Road as well, too, which is the name of that.
We didn't talk about him using Short Neck Road. We were merely talking about citizens. Okay. So we should just remind him that he can't use Short Neck Road.
That's right.
And I don't know that he knows that he is, but we can remind him of that.
For construction, for passage of construction?
For passage of
Yeah,
construction.
he was notified very clearly that both Cahoon and Short Neck were off limits for construction vehicles.
Right, so he's aware of that, he believes that he's complying. If his construction vehicles are not, we just need to notify him or notify them, and it should stop.
Okay.
And again, to your point, if he doesn't stop, then Mr. Turner can move forward with his,
Yeah, he was informed that if the passage continued, that Mr. Turner would be down there with a cease and desist.
yeah. So do we think it's still happening, Ken?
No, I haven't heard any complaints either.
Yeah,
Okay.
I haven't received any either.
Okay. So we think,
We think that's under control.
and I think Mr. Fay's only request is before shutting him down, if somebody told him that it's still happening so that he could respond quickly, that would be his only ask in that case, I think.
Yeah, I mean, if he's got a rogue vendor that's not playing nice, then that would be the right thing to do, is to make him aware of it and say, hey, you need to reach out to XYZ Plumbing and tell them this is not acceptable.
Right.
Yeah.
Okay, so that was our report, and I've committed to meeting with him anytime that he needs to double check. I think we've got 2 or 3 action items here, Ken, that we'll follow up on. I'll go back to the tape and write them down.
Perfect.
Okay.
Thank you. That was a lot of work. Now I understand why your hair's gray.
You did have a question from a citizen. I don't know if you want to, I will be glad to answer the question if I can, but...
Yeah, I don't know if I want to get involved in public comment, to be honest, because it's really not a public hearing.
It's up to you.
I
I'd recommend hearing them. These guys have been here for 2 years
Yeah.
now.
All right, if we can keep the
it
concerns short, and then we can take a stab at it.
I can speak from here because I'll make it quick.
No, yeah, gonna make you walk the walk.
Okay. George Salem, president of Bay Point Village Condominiums, which is adjacent to this project. We have been working through Attorney Morton, which I believe she has been in communication with Mr. Buckland. But it's her wedding weekend, so I'm here just to speak real quickly. Part of our property abuts Cahoon Road. During the construction of Phase 1, there was some property damage, which consisted of removing about 17 of our hedges, digging up our frontage, and taking down a street light. The street light is a safety concern for us. All this was done by Mr. Fay, and there was no ask on the street light. He just took it down. We have submitted to the board, the planning board, that we would like restitution for those 3 things. And we have been working with Attorney Morton, who's been communicating, and so I hope you guys are aware of that. And I just want to make sure that that's on the record for things that have not got done during Phase 1. It is in the, what's it called, the site plan and special permit that he must restore that property, whether it's ours or whether it's the town. I believe it's on the top of page 6 off the top of my head. And I just want to make sure it's on your radar since Attorney Morton could not be here today.
Okay. The planning office has received correspondence from this attorney?
Yes, we have.
So we have the list of grievances as far as what they feel needs to be restored back to pre-damage condition?
I believe we do.
Okay. And to be honest, I mean, we have spoken about these 3 items several times, so it's not new business. So it would be nice maybe if we can incorporate that discussion into the completion of
Yes,
Phase
yeah.
1. Yes.
Okay, and we need to confirm that's because my research indicates that it was not a condition of the special permit, and Mr. Fay believes this is a legal discussion between him and the applicant. We did discuss that I asked him the status of that. He said he hasn't heard from you in a while. This is what he said.
And I don't want to get into the,
No, I'm merely reporting, and he believes that's a legal issue, not a planning board issue. And I guess we should, I was planning to confirm that when the inspection occurs.
okay, yeah, so. all
But
right,
I
so we'll
believe it's a,
confirm- We'll confirm that those items are still left
or they
in
were,
dispute.
right. Yeah, they're in dispute, but whether they're the scope of site plan special permit or subdivision, or it's a legal dispute between the applicant, I thought we had resolved that as it being
I
a
was under the
legal dispute.
impression it had been dealt with too, to be honest.
At one
And-
point, he agreed to finish
He
it.
did.
More than once.
In one of our meetings, he agreed to complete those repairs. I remember it very clearly.
Right. But
And
if,
this goes back to, just like when we're talking with the solar developers and whatnot, about being a good neighbor. You know, you back over someone's mailbox, you fix the mailbox. I mean, that's just how society works. So, but we'll add these items for review. If they do turn out to be a true legal discussion, that is gonna tie our hands. You know, we're not gonna be in a position to assist you with that, but we can at least bring it to the table for discussion and see where it takes us.
I did not forget that. I did bring that up with him. His opinion is that's resolved.
Okay. We have a lot of issues with them, and most of them are legal. That is the only one that we do believe is part of, that is in the site plan review.
Right.
Special permit.
Wow.
And,
We can work on it from our side. If we
just-
find that it is, then we can deal with it.
Just one more update, not part of the site plan review or special permit, but we did hear all the complaints about the heating system, and I just mentioned that to him again. Not within our purview, but
Yep.
it's,
Still residents' concerns.
I think he recognizes that, he didn't tell me that that had been resolved, but he didn't give me a plan for resolving it either, and I didn't press it, because that's beyond our scope.
okay. Very good.
All right, thank you.
I appreciate you guys so much, all of you.
Alright.
Thank you.
All righty.
So I'll summarize, Ken, between you and I, the 2 or 3 action items that we took, and then one of us will get back to Mr. Fay with the as-built plan.
And what we're waiting on from him.
Right,
All right, very good. Thanks again. That was a lot of work.
right. And then separately, I think the planning board needs to meet with the planning office and talk about what do we do with 6-year-long projects where we can't find, clear documentations. Some of this would help. I don't know, Mr. Buckland, do you have access to the Plymouth Registry of Deeds where we could actually print out the covenants and to see if they were closed out properly?
Yeah, I do.
Okay, so maybe that would help us as well.
Yeah, if we
I don't know what we want to do, but I mean, we're now moving into the era of, we've got solar projects that are going to be,
Yeah.
I don't know how long
Yes.
Mr. Clavin's project is, but it's 3 years and growing teeth. Fearing Hill is
At least the third year.
that old. We need to make sure that we can quickly bring up historical, at least legal artifacts, not necessarily every citizen email, but certainly the
Not hard to have a disc.
right. So just a thought of how do we improve that, particularly now that Mr. Buckland has lost his planning assistant.
Assistant.
Mm-hmm.
Okay.
Jonathan, yeah, he's going.
Okay, I don't want to head down the rabbit hole on this subject. This is actually just a subcommittee report, not a public hearing.
When did that happen?
So if you can keep it brief, like Mr. Salem did, we're good.
Like maybe a month.
And then this will be the last comment.
Mayor Souza, 39 Bay Point Drive. I think the as-built plan is critical because many of our shut-offs are buried. They're buried in the driveways, sidewalks, they're in the lawns. So if there's ever an emergency, we don't have access to some of the gas, some of the water shut-offs, some of the sewer cleanouts are buried. We've had 3 incidents of blocked pipes thus far, and the only way we found out is it backed up into the house. Okay, there was no opportunity to look in, periodically check it to make sure it's not blocked, because the blockages were in the street, because they hired a guy with a camera to come in and do it. So I don't know where problems are, but that's occurred 3 times, okay? So that's why to us, because I was responsible for some of these areas and other condos, and that as-built plan is critical, because it tells us where all this stuff is, or it's supposed to. And in one of those permits, it says that thing was supposed to be available when the final coat in the road was put down. That was December 2021. It's a year and a half. And it's specifically stated in there that the as-built plans will be delivered to 4 different departments, to Mr. Buckland's, to
Water, sewer.
water, utilities, the maintenance department. So I've asked for it several times, other people have as well, and we've gotten nowhere. And that's critical because we move on as a separate entity and he moves on.
Right.
So we need to know, we don't know where the installation is for the sprinkler system, we don't know where the control valves are, even the cable, some of the routing of the cable stuff, we have no idea.
Okay.
So I would appreciate anything you can do.
All right, thank you
Thank
so
you very
much.
much.
All right.
Thank you for your work.
Okay. Moving on. Ms. Sherry, you're up.
Okay. Ken, do you think that there is a way that we could bring the PowerPoint up to view during this session?
That's what I'm trying to do right now. Do you have it
Oh, man.
on a thumb drive?
I do not. Could we take a 5-minute break and see if we can bring this up?
Sure.
Okay,
Actually, that's
great.
perfect.
Thanks.
That's right, 7:30. That was the number.
Well, 7:32, because you started.
All right,
So I
perfect.
move that we take a 5-minute.
5-minute break.
Well, I think that Carl should give me some time back.
Okay.
And I agree with Sandy, he always agrees, he's lousy.
You may want to look at other sections of the bylaw.
We're up.
It's not going to be hugely.
Let's rock and roll. Yeah, be careful, Ken. If Kyle has his...
I'm writing, I was trying to make points. Make a motion.
Be quick. No one, oh, we can fire.
Yeah. Hey, Ken, do you want me to run that?
If you want to, sure.
I don't know where he went. They fired him one day. Tell you about it.
I'm gonna let you be a presenter.
Come on. We have it. If Kyle gets his way, we'll be here till 10 o'clock.
Shall we short?
That's because you stood up at that
Said your
meeting,
short
said you were gonna
presentation?
take charge. I'm waiting for the solar guys to come down.
All righty, we're going to get started again, folks. So, Sherry, if you care to share your work.
Sure. I'm going to run this, if at least to give Ken a break.
Yeah,
Thank
really.
you. Yeah, I can't read mine.
And beer.
Okay, so here we are to talk about battery and energy storage again. And as I said earlier, Carl and I have been looking at this issue for a little while as it's been coming up in our cases, and as we have, done some work on, an alternative energy sort of task force where we're looking at some of the emerging issues on alternative energy, including battery storage. And so what we're trying to do is to start shaping up some ideas for a bylaw, something to present to town meeting and to go forward with. And, in order to do this, we need to take a look at preferably at what other jurisdictions have done and to see if there are some things that we can draw on. But really to start out with the idea of what will work for Wareham. So, let's see here. So, just to let you know what we're looking for from you tonight is we want to share our research and then think about, given what other people have done, what this board might want to do differently, do the same, et cetera. And fortunately for us, there are some good examples out there. And as we talk about, developing bylaws, that looks a little small. Can you guys see that?
No, we can't read it.
Can you read the bullet points for them, Sherry?
Sure. I'll read the bullet points. So there are some examples out there, but I guess what I want to stop and say is we're talking about a bylaw now. What we've been talking about in the cases where we've dealt with battery storage is more in the nature of conditioning authority for, under our existing bylaws and existing law. And so, whereas in one situation we're talking about conditioning and health, safety, and welfare, some other legal standards, in this case, we're looking at developing specific standards that will see what should ideally be in place for battery storage to go forward under conditions that would be safe. So just let you know that the state of New York has developed a recommended zoning bylaw that has a series of conditions in it. The town of Medway, Massachusetts has done the same. They hired an entire team of consultants to look at a large battery energy storage project coming to town. And this group of experts looked at what, in their view, would best suit the town. And again, this was a very large project, 250 megawatts. And so they have looked pretty carefully at a larger battery setup than we have been facing. One of the things we found out, though, is, or some experts have told us, is the size of the battery, to some degree, the fact that it's smaller does not eliminate the risk of thermal runaway, which is what our big concern is. The town of Carver also had a large battery storage project come to town, and similar to Medway's. And what Carver did at its town meeting as well, its recent town meeting, was to develop a battery energy bylaw that I've looked at as well. Now, just to give you the rest of the picture with Medway and with Carver, both of their large battery projects are now before the Department of Public Utilities, and the DPU is looking at the question of whether it will preempt local zoning for those projects. The siting board decided that, after carefully reviewing its statute, that storage is not generation, and therefore the siting board does not have jurisdiction over it. But there's still a question before the DPU about whether they will preempt local zoning. So next we look at what's the problem we're trying to solve here? And, we've had a chance to look at battery issues in several of our pending cases, including Zero Route 25 and the Borrego cases. And we found ourselves sort of pausing over the question of impact on health, safety, and welfare, and having some concerns that have come up. And I would say, for me, this is a little bit like an issue where it looks like the technology and the deployment of technology is racing ahead of regulation. And I mean, certainly in the energy field, we see this from time to time, where you have development of technology or development of different structures, different ways of doing business. And it takes a while for the regulatory process to catch up to it. And in the meantime, I think, it's a good idea to take some care and make sure that what we do in this town is safe for our people. And so what do we need to consider? Is there a way for Wareham to address its concerns? To take a look at the battery storage projects in front of us, which are, smaller than the ones that we're seeing in Medway and Carver. Is there a way to address these concerns and say, for this planning board to say, we can say yes to this battery project and we can sleep at night and not be concerned? And in looking at the other bylaws that have been developed, are there any particular modifications that Wareham needs? Are there some differences between Medway, Carver, the state of New York, and Wareham that require some specific consideration? I thought, Carver being right next door, and on the theory or the thought or possibility that some of you all may have been involved in the development of that zoning bylaw, I thought I'd go over that one a little bit, see what's involved in it. And I would say that some of what is in that bylaw is similar to what Zero Route 25 and Borrego have recommended to us, that they would be willing to adopt as conditions for their batteries. So there's going to be some overlap here, and maybe some other things we want to look at as well. First big thing is, you all know that there are batteries all over town. And I just got back this afternoon from New York City. We know there are batteries all over town because the e-bikes have been, suffering a series of events, and they're big news there. So there are batteries everywhere. The zoning bylaw in Carver differentiates based on size. And the smaller size batteries are not subject to review under this bylaw. They're just, as of right, subject to compliance with state law and, with accessibility for the fire department. Now, it'll be interesting to see whether or how that may change. I know for people with those smaller batteries, insurance issues are becoming more difficult, as insurance companies do see more issues with these. Now, the Carver bylaw establishes setbacks, the 300 feet for larger batteries, and residential units, 150 from wells and septic systems. So, some setback from sources of water and from residential areas. Carver requires mitigation for loss of forests, trail networks, and disruption of historic resources and properties, which is, I thought was an interesting thing for us to look at, not something that is in our bylaws at this point. Proof of liability insurance. I would like to know more about what that means and what type of insurance that might be. I, have some familiarity with liability insurance from my days working for a utility, and know that not all insurance is created equal, and insurance can be permission to bring a lawsuit as opposed to any guarantee of any recovery. So I'm cautious about insurance myself. Decommissioning plans for the battery projects, because the understanding is that the batteries upon decommissioning can contain metals that are very dangerous to the environment and need to be treated with care. Now, importantly, on this next page, it says commissioning plans showing compliance with NFPA 855. This is a really important provision. NFPA is the National Fire Protection, I think it's association. This establishes an entire regime for bringing a battery online, you know, how it is interconnected, how it's put together, and also requires an emergency operations plan that has been approved by the fire department, emergency procedures to be followed in the case of fire, explosion, release of liquids or vapors or other potentially dangerous situations, other procedures as determined necessary by the town to provide for the safety of occupants, neighboring properties, and emergency responders. And, you know, these, I mean, you could probably read this and hear this concern in what was discussed earlier, which is if there is a fire event and if there are, you know, depending on what steps are taken to take it out, to put it out, how will those steps be addressed and made safe for the town as well? Requirement to report ownership changes. You know that I've talked in the past about concern about us knowing who we're doing business with in terms of this town and who is operating these types of facilities here. And the facilities need to be approved pursuant to UL 9540. This is an underwriter laboratory standard that requires testing of battery facilities, and it's intended to make sure that they are of a safe design. And I have, you know, been fortunate enough to watch a video of a UL 9540 test. I would encourage you to do so. It's and this is serious stuff, very, very important. If we go on to what issues we need to consider, and I would say number one is in terms of level of danger, I would say, as opposed to likelihood of happening. Level of danger, if it does happen, very, very difficult. There's a fire water runoff in the event of an accident. And we have water that is, from what I understand to be toxic, potentially going into groundwater, our aquifer, our wetlands, our, you know, water resources generally. As I said earlier, this town is nothing if not a beautiful set of water resources, and I think we want to make sure that we take care of it as well as taking care of the people who depend on it. Water quality, air quality. Yeah, with the fire events, there is a release of gases that can be very dangerous. You know, interested and curious to know how this can be addressed by our applicants. Evolution of technology. Again, this is a technology that is in transition. Lots of work being done on it, as well as on other competing battery technologies. And we simply don't know if what we're seeing today is what we're going to see a year from now or 2 years from now, or, you know, any given period from now. And so, you know, I think we have to bear in mind that we have to be looking at these issues in a temporal or time-related basis. How is it going to change over time? Addressing decommissioning costs, just as with the solar panels, even more important with the metals and potentially toxic materials in the batteries. Other potential liabilities, that sort of, you know, that is Wareham as a small town, always struggling to make its budget, always struggling to figure out how to spend as little money as possible on anything except essentials. How is it that we don't take on other liabilities in getting into this area? And legal requirements, again, I would say it's a little bit, it's interesting to me that a town like Wareham is looking at issues like this. That as a small planning board in a small town, we're looking at issues that present the complexity of battery storage issues, and there aren't, legal requirements or safeguards coming from our state on this. It would be, in my opinion, better if the state were to come in and say, we're going to be helpful in this area, in these areas, while not preempting your authority, but providing you resources and help. So next steps, what I would really urge people to do, which I think would be helpful to the alternative energy group as we go forward, take a look at Carver if you haven't already, or you weren't one of the co-drafters of it, and tell us what you think about it. Tell us what you think is missing or shouldn't be there. We're going to be looking at this really carefully in developing a draft bylaw, and our target is not the special town meeting, but the next special town meeting in connection with a regular town meeting. So the fall.
Fall town meeting.
Yes. And so that's not a lot of time, but we've got a lot to work with. And what I would like to do with the chair's indulgence is to bring us to a public hearing where we could hear from people and get some input on going forward, and then to take those steps toward town meeting. So, and I think it's, we're not the only ones struggling with this issue. I think everybody, well, not every, but that's an exaggeration, but many people are. And I'm hoping with the applicants that we have in front of us, that they remain committed to helping us to work this out, and to see if we can come to a place where we can do what is reasonable, and not do anything that is dangerous, risky, or a bet the town kind of thing. So that's what I have. So any questions?
Some of these things we've been talking about for quite a while. We get yelled at. No, very informative. You and Kyle have put in way too much work.
Just a comment.
Of course.
Sherry, you and I haven't talked about it. The idea of holding a public hearing, just as a note, there's precedent for that. When we did the solar bylaw, the planning board hosted a public hearing, and we took statements from the
And citizens.
whoever came, and we did a typical analysis. We wrote down all the recommendations. We counted how many instances of that, and we used that. We're not necessarily able to respond to every comment, but certainly there is precedent. It was an off-cycle meeting. It wasn't at a regular meeting.
Yep, I think that's a great idea, too.
We record it. We capture the recording. We take our notes from that. So I'm supportive of, as you know, doing that.
Yep.
Great. And I'm expecting also in, for example, the Borrego proceeding, we're going to get information there as well that will be informative to what we're doing in developing a bylaw.
Very good. Any other comments, questions, concerns?
I'd like to make one.
Sure.
Don't forget the people who you elect. They're telling us what to do and taking options away from us. And if you look at some of what your congressman has put forward, you wouldn't agree with it, yet he gets overwhelming support. And my opinion, we're being forced to do things that we should not be forced to do. We have a single source aquifer. We don't have any guarantees. Nobody can guarantee everything, but somebody has to come forward and say, okay, this is the best plan. Your aquifer is going to be protected. If it's not, we have no Wareham. We have no water. I don't know what percent, but the vast majority of Wareham is on the aquifer. There have been accidents all over the world. There have been pollutions, and if it happens in Wareham, there's no more water. And that's something that has to be addressed seriously and taken seriously. And to my first point, find out what your representatives, senators, and congressmen and senators are doing. Because some of the things they're putting forward, you'd be appalled at. You wouldn't agree with it, but you vote for them. So that's all I'm going to say. Thank you.
Anything else?
Sherry, did you want to make a note that the learnings about battery and are going to require us to update Section 590 of the solar bylaw, and we'll have to put forward updates to that bylaw, the fall town meeting likely as well.
Thank you, Carl. And actually, it's just pretty much as Carl said, that the solar bylaw, which was developed and passed a year and a half ago, still pending AG review, needs to be reviewed and needs to have the battery pieces in it updated and reviewed as well, and probably also some other pieces also. But, I think the thought is that we haven't talked about this yet, but what I've been thinking is that we would develop an adjunct battery piece that would be referenced in the solar bylaw, so that, they would be a bit separate, because there are batteries that are not solar. And we don't know, for example, in the future, what kinds of batteries there may be. But we need to have clear guidelines for batteries that are in connection with solar.
Okay. Thank you very much. With that, I would, is there any other comments or questions on this particular subject before we move on? No? Okay. Thank you,
Yeah.
Sherry.
Thanks.
Okay. A little bit of,
Just on this topic, it's a question through you to Mr. Buckland. Ken, is there any value or advantage to these updates we give on either solar or the battery subcommittees to make them part of the record of all the open solar projects? Or is there a value to that? Is there a procedure for that? Just so they're on the record?
We can post them on the planning board website under solar projects or something, and solar studies.
so
Okay.
that would be applicable to all solar projects
So
at that
Right.
point.
Okay, so that citizens are aware, the applicants are aware,
Yeah.
yeah, so that we don't have to.
There'll be a collection point
Good.
for all the studies
Yeah.
we've been doing.
Yeah, we just don't want to have to introduce them manually every project that comes up or every time it comes up.
That's right.
Okay.
So this will get posted to that.
We can store related documents under there as well, too, like the NREL's report as well, or something like that.
Okay, all right, perfect, thank you. Okay, other business. Been waiting for this all night. So we have a little bit of housekeeping for the board here. So the first order of business is I would entertain a motion to reappoint Sam Corbett as the planning board representative to the capital planning committee. Do I have said motion?
Discussion, does that mean he's going to the White House, or should we reappoint him to the Capitol Planning Committee?
Right to the top. Maybe you can straighten things out.
I'm sorry.
So, looking for a motion.
So moved.
Second.
Okay, we have a motion by Carl Schultz, seconded by Sherry Quirk. All in favor. Sherry?
Aye.
Mike? Jane?
Aye.
Sam? Come on, don't hold out on me, buddy.
Stay.
Abstain. Carl?
Aye.
Chair votes aye. Congratulations, and thank you. Next
How
order of...
much fun is this committee?
No, nothing's as much fun
I
as
know.
this committee. Next order of business would be entertain a motion to reappoint Mike Baptiste to the planning board for another 3-year stint, as his term is up the end of this month.
So moved.
Boom.
Second.
Boy, you were tossed right into the wolf's den like that. We have a motion by Sherry Quirk, seconded by Jane Gleason. All in favor? Jane?
Aye.
I'm sorry, Sherry?
Aye.
Mike? Jane?
Aye.
Sam?
Aye.
Carl?
Aye.
And chair votes aye.
So Mike, how long have you been on the planning board now?
Long time.
I think
Not
he's the
yet long enough.
longest-serving volunteer in Wareham right now.
Yeah,
I think Dougie Westgate, I think, had me beat,
Really?
he come
not by
right,
much, but.
he came right out of kindergarten, went right on aboard. Then, last but not least, I entertain a motion to reappoint Sherry Quirk as associate member to the board for another 1-year term.
So moved.
Second.
Have a motion by Sam Corbett, seconded by Mike Baptiste. All in favor? Sherry?
Abstain.
Mike?
Aye.
Jane?
Aye.
Sam?
Aye.
Carl?
Aye.
And the chair votes aye. You can run, but you can't hide. And with that, is there any other business or comments that somebody needs to make, or can we go for that all-important motion?
Make a motion, we adjourn.
Do we have a second?
Second.
Motion by Sam Corbett, seconded by Mike Baptiste. All in favor? Sherry?
Aye.
Mike?
Aye.
Jane?
Aye.
Sam?
Aye.
Carl? Want to abstain?
Aye.
Chair votes aye. Thank you, folks.